my name is Jennifer Preston. I work for Canadian Foreign Service Committee, which is the justice body of Quakers in Canada. And my colleague is Paul Joffe, who's a legal counsel to the Grand Council of the Crees in UBC, which is the Crees in northern Quebec. And we work together, and we also are both active with the Coalition for the Human Rights of Indigenous Peoples. And these handouts, the handouts that we had were documents that were produced by the Coalition this year. And the Coalition has a website, which I think is something super simple, declarationcoalition.ca. So these resources are on that website, and also some of the other documents that we may make reference to are also on that website. There's a lot of useful things there. So we just, in the previous workshop, we talked about the UN Declaration specifically because Paul and I were both involved. Paul for the whole time period, and myself not the whole time period, but we were both involved in the working groups at the UN that developed the UN Declaration on the Rights of Indigenous Peoples, and we worked together in the political sphere when the lobbying needed to be done to have the declaration adopted by the United Nations. And so we came to the conference to give that history on what the declaration is and where did it come from and how can you use it. But then, and so we didn't in that first presentation talk about FPIC and the declaration because that's what this presentation is about. So I think everyone got, when you registered for the conference, when you got your bag, you got a copy of the booklet. And the booklet was also produced by the Coalition. So everybody should have that. I have 3 copies of a booklet version of the Truth and Reconciliation's 94 Calls to Action. I'm sorry, I have 3. But anybody who would like to have one of those 3, you're welcome to those. We have one other document up here, which you may want to wait until the end. And if people, April only printed a few of these because it's a big document. But Paul has written a legal paper on the difference between veto and consent. So this is also on the declaration webpage. So if you'd rather have an electronic version of it, you can go there and you can find it. But there's a few hard copies of this paper here. Okay, so as I said, we just did a whole session on the UN Declaration. So I'm not going to open with repeating any of that information. But I also just wanted to mention there is a second Human Rights Declaration that applies for Indigenous peoples in the Americas, which is Canada, the United States, Latin America, and the Caribbean. And that's called the American Declaration on the Rights of Indigenous Peoples. And I think it's less well known. Well, I know that it's less well known. It was adopted by consensus in June of 2016. It was developed at the Organization of American States, which is headquartered in Washington, D.C. And again, Paul was involved from the beginning in that, and I was involved towards the end of that process. But the American Declaration we will be referring to in this presentation as well. The one thing to think of with both of those instruments, some of the provisions are exactly the same as a corresponding provision in the UN Declaration, and some of them the provision goes a little higher, and some of them the provision doesn't go as high. And so the rule is that the highest provision, whether it's the American Declaration or the UN Declaration, is the one that applies. So in this workshop, we're going to talk, obviously, about free, prior, and informed consent. Paul's going to open with a little bit of just explaining what that is and a little bit of what that isn't. And then we're going to talk about international law and consent, Canadian law and consent, and then Indigenous cultural rights, and finally, sustainable development. So that's what we're going to cover in 55 minutes, and we should have time for some questions. So Paul's going to start.
Okay. Sometimes FPIC, or free, prior, and informed consent, is dealt with as if it's some kind of new animal. It's this strange thing that's never really had FPIC. And so I'd like to start here, and I'd like to emphasize with this slide that there is no significant difference between FPIC in international law and consent in Canadian law. And as illustrated on this slide, in both instances, when we are addressing consent, first there must be no coercion or manipulation. It's the same rule for both. Consent must be obtained in advance of the activity being approved. And third, information provided must not be misleading or inadequate. And without these elements, there would not be valid consent. Now, FPIC or consent does not originate with the UN Declaration, as Jennifer mentioned in our previous session. The Declaration does not create any new rights. The Declaration includes inherent or pre-existing rights. So the question is, where does consent come from at the international level? And the key source of consent, of course, is the right of self-determination. And the covenants say, as I mentioned both at the bottom of the slide, that all peoples have the right of self-determination. All peoples. And that should have always included Indigenous peoples. And basically, the right of self-determination includes the right to choose. It's the right to say yes, the right to say no, and I would add the right to say yes with conditions. And Indigenous peoples, of course, have their own internal processes to make a decision. They don't just say, or we don't just say, oh yes, yes or no. You go through a whole process. So again, it should be given a lot more respect. Now, if we go to the third paragraph, since there's a lot of time, Article 1.3, as you see on the screen, includes an affirmative obligation of states, including Canada, because Canada ratified, to promote and respect the right of self-determination. Not only to respect, but also to promote, and that's not happening. And Canada ratified the two covenants in May 1976. That's over 40 years ago. And yet self-determination and consent of Indigenous peoples have not been fully acknowledged and respected by Canadian governments during that whole period. That's where it comes from, and it's an obligation. So it's a legal obligation. And again, for court cases, that makes a big difference. Now, Article 46.3 includes one of the most comprehensive balancing provisions in any international human rights instrument. And Jennifer has mentioned some of it last time. I'll just mention a little again. It affirms, first of all, that the rights in the UN Declaration are generally relative, not absolute. And the only right in the Declaration, which is absolute, is the right not to be subjected to genocide, which is absolute in international law. And Article 46.3 affirms that every provision in the Declaration must be interpreted in accordance with the principles of justice, democracy, respect for human rights, equality, non-discrimination, good governance, and good faith. And these are the same core principles in the Canadian and international legal system. So Canada can't have any problems with these. These are also the same principles, as Jennifer mentioned, that have been denied Indigenous peoples throughout history. And FPIC, in my view, is not the same as veto. The term veto is not used in the UN Declaration. And veto implies an absolute power, regardless of the facts and law in any given case. So, you know, I know that there are people who like to say consent is a veto, but if you have many First Nations and they're all taking different positions, they can't all have the absolute right to decide what happens. Human rights, as we said earlier, are generally relative. Now, that's you, sorry.
Okay, we have a couple of quotes here from a new study that just came out. At the United Nations, there's several different mechanisms that deal with Indigenous peoples' rights. And one of them, and the newest one, is the UN Expert Mechanism on the Rights of Indigenous Peoples, or MRIP. And MRIP is housed in Geneva. And part of their mandate deals with the implementation of the UN Declaration and following what's happening around the globe with the implementation of the UN Declaration. And in addition to the work that they do, in different areas. They also can produce on an annual basis a thematic study. So this past year, the study that they released was on FPIC. And it's an important study, and I would say for those of you particularly that are working on this issue, I think we gave copies of it to April, and so it is available. I mean, it's obviously available online. But this comes from the MRIP study on FPIC. And as Paul mentioned, that it's not new in international human rights law, and that it comes from the right of self-determination. So they conclude that as well. But they also go further, interestingly, and they conclude that FPIC is a way of operationalizing self-determination. And I think this is a very interesting way to characterize it, because the right of self-determination, as Paul said, this is an affirmative right. Canada ratified those conventions in the mid-1970s. But what does that mean? What does self-determination mean? I mean, at its core, it means the right to choose. And so here we have this expert body saying that it's operationalizing self-determination. And so I think that's an important way to connect FPIC and self-determination to as well. And this is also from their report. And in this, they are drawing the obvious links on three interrelated rights of Indigenous peoples: the right to be consulted, the right to participate, and the right to lands, territories, and resources. And that FPIC cannot be achieved if one of those components is missing. And I mean, I think that's obvious. So often when we're talking about FPIC, it's in the context of resource development or rights to lands. So I think that's another interesting piece from their study. But I do encourage you to take a look at that study. So the UN Declaration has several provisions that deal with FPIC, and over the course of this presentation, we'll have a few of them up on the screen. And this one is Article 32. Article 32 is discussing development and Indigenous peoples' right to development, and the right to development also comes from the right of self-determination. So again, tying FPIC and the right of self-determination, the right of development, all of those pieces are interrelated. And the second part of Article 32 discusses how states have to consult and cooperate in good faith in order to obtain their free, prior, and informed consent prior to the approval of any project. And this is so much more than just a process, so much more than a consultation process. And also, we discussed in the earlier workshop how the Government of Canada's 10 Principles talks about to seek consent. That phrase is not in the UN Declaration. Indigenous peoples fought to ensure that it would not appear in the UN Declaration, because it's a much more limiting phrase to say, in order to, I mean, you can say, well, we sought their consent, but we didn't get it, but we went through our process, so we're going ahead. To obtain is much stronger language than to seek. And so I think that's an important distinction. So this, up on the screen, this comes from the United Nations Global Compact. And the United Nations Global Compact is the world's largest corporate responsibility initiative. And it has the participation of more than 9,500 companies in over 160 countries around the world. So they developed a reference guide on the UN Declaration for their membership, because so often corporate activity is taking place on Indigenous peoples' territories. And these are just two paragraphs coming from their business reference guide. But in it, you see that they also conclude that FPIC is fundamental to the UN Declaration. And they go on to say, as a measure to ensure that Indigenous peoples' rights are protected. So they're talking about FPIC as a safeguard. So it's not just FPIC as a standalone right, but it's as a safeguard to ensure that Indigenous peoples' rights are being respected. And they also conclude that FPIC must be obtained when there will be impacts on lands, territories, and resources, and self-determination. And this, up on the screen, we have a quote from the former Special Rapporteur. And at the United Nations, there's a variety of Special Rapporteurs. They're actually called special mechanisms, even though obviously it's a person. and they had on different themes. So there is a special rapporteur on the rights of Indigenous peoples. The person that was formerly in this position is Professor James Anaya, and he did a report of the situation of Indigenous peoples in Canada. He came to Canada, he toured around, and made a report. So in his report, he concludes that as a general rule, resource extraction should not occur on lands subject to Aboriginal claims without adequate consultation and the free, prior, informed consent. So, and this is really helpful too, because it's he's saying this is a general rule that you should not proceed without FPIC, and that was his report on the situation in Canada. This is from another international body. So, at the international level, in international law, there's a series of international treaties or conventions. It's the same thing. It's those two words are interchangeable. And states, when a convention is negotiated, states can ratify or not. And so this is the Convention on the Elimination of All Forms of Racial Discrimination, which Canada has ratified. And when a state ratifies an international convention, they have a legal obligation. And so once you've done that, you then have to do reporting to the UN on what you've done to implement that convention in your state. So in Canada, was up for a review in 2017 by this committee. It's called CERD. In their report on Canada, they said, this is just a year ago, that they're deeply concerned that the violations of land rights of Indigenous peoples continue in the state party. Environmentally destructive decisions for resource development continue to be undertaken without the free, prior, and informed consent, resulting in breaches of treaty obligations and international human rights law. So that's coming, and remember, Canada has a legal obligation here. And this is another quote from James Anaya, and this one was when he did a report simply on extractive industries and Indigenous peoples. And he's talking about, so this is broad, it's not just for Canada, but when consent is given on terms that are protective of Indigenous peoples' rights, it will fulfill its safeguard role. So the whole point of the safeguard role is that it is understood that for centuries, Indigenous peoples' human rights have been violated, often because of large-scale dispossession due to resource activity. And that means that Indigenous, not only does FPIC exist on its own for what it is, but it has to exist to protect Indigenous peoples' rights. That states have to get FPIC, they have to get consent, because you can't increase the vulnerabilities that already exist because of the extensive human rights violations that have already occurred through centuries of exploitation. And the reason we were sharing all those different quotes from international bodies, and by the way, both of these presentations, I'm happy to send them to anybody who wants them, so that you can have those. We wanted to share them because they show you this breadth at the international level of people using FPIC. FPIC is the standard in international law, and people aren't sort of, being wishy-washy about, well, maybe it's to seek, or maybe it's just consultation. It's the standard. And so you can see through those different treaty bodies and UN expert bodies, this is just something, and it's also, there's many others that we didn't show us, but we just wanted to give you the breadth of the use of FPIC at the international level. And this last one that I'm sharing, comes from the Inter-American Court of Human Rights, and which comes out of the Inter-American system. And precedents in the Inter-American system can be used in Canadian litigation. And in this case, the court decided that large-scale development or investment projects that would have a major impact, the state has a duty to obtain their free, prior, and informed consent. And then the court went on to say, according to their customs and traditions. And so this is important, and I'll come back to it later in the presentation. This is also making a reference to Indigenous governance. So it's not a process that was set up by the state. It's how Indigenous peoples want that process to look like according to their customs and traditions. And now I'll give it to Paul.
Yeah, so you see here Article 19 of the UN Declaration, and it says, states shall consult and cooperate in good faith in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. And the same text has been affirmed exactly in the American Declaration on the Rights of Indigenous Peoples. And for those who want to know, it's Article 23, Paragraph 2. And again, it was easier at times to negotiate the American Declaration because once we got it in the UN Declaration, there was less opposition because it's a lot of the same states, or pretty much all of the same states. In the recent Supreme Court decision of Mikisew Cree versus Canada, which we discussed a little in the earlier presentation, which I did mention has been pretty much a disaster in many ways. The court held that the federal government has no duty even to consult when they're switching from acting as the executive branch to being in the legislative branch, and the court claimed we can't interfere. The decision didn't consider, as I mentioned earlier, any international human rights law. Maybe that's a good thing in the sense that I'm not sure if people involved were prepared to put forward the best arguments in international human rights law. So better than not get a negative precedent for the Declaration of Human Rights Law internationally. Maybe it's better than didn't. And you mentioned earlier, strategically, you never bring up, in any case, the UN Declaration just arbitrarily or throw it in as an add-on. You only bring it up if you're really serious about defending and protecting your rights that are affirmed in the UN Declaration. And anyway, I'll leave it there, but this is the provision relating to legislation. And I should say one other thing. There are treaty bodies who have said that you should use free, prior, and informed consent. You should respect, states should respect when they're doing legislation. So in fact, there are precedents at the international level. Here we have Tsilhqot'in Nation versus British Columbia, 2004. And in my view, consent should not be limited to Aboriginal title. In the next couple of slides, I'll deal with Aboriginal title, but there's no reason that consent should only be for Aboriginal title cases. So, as we see on this slide in Tsilhqot'in Nation in 2004, the Supreme Court described the duty of the Crown to consult as a spectrum. And so at the low end of the spectrum, the duty to consult includes, as you see on the slide, a minimum duty to discuss important decisions where the breach is relatively minor. That's at the very low end. However, at the high end, this duty requires, you see it on the screen, the full consent of the Aboriginal nation on very serious issues. So very serious issues could entail a whole range of issues. It's not just climate change. And it is disturbing, in my view, or in our view, that the Supreme Court of Canada has never ruled in any case that full consent of the Indigenous nation is required on very serious issues. It cannot be that, very serious issues never came before the Supreme Court. So that's a concern that they put it in the law as part of the Constitution, and they've never relied on the strong part. Now, in Tsilhqot'in Nation, turning to an Aboriginal title case, the Supreme Court concluded that the right to control the land means that governments and others seeking to use Indigenous land must obtain the consent of the Aboriginal title holders. Now, in my view, such a right to control would also entail governance powers. And in this context, if you look at the bottom of the screen, referring to the UN Declaration and the American Declaration. It's worth noting that Indigenous peoples have the right to own, use, develop, and control their lands, territories, and resources. So again, you see the word control, and control would include consent, because if you don't have the right to give or withhold consent, you cannot have possibly control. And of course, also there's the governance aspect, which I'll get to now. Now, in Tsilhqot'in Nation, the Supreme Court highlighted Indigenous peoples' consent in 9 different paragraphs, and the right to control the land in 11 paragraphs. So we already mentioned that control can mean consent. So when you're looking in the Declaration, where is consent being mentioned? Don't only look for the word consent. We know that if there's the right of self-determination, that includes consent. It doesn't say the word, and self-determination relates to all other rights. And then here, we're referring again to the word control, and it includes consent, even though the article in the Declaration might not say consent. Now, it went on to say, just to go on, the right to control, controlling land use, and proactively managing the land, which you see at the bottom of in the first quote, right? The right to proactively managing the land, and controlling land use, also entail lawmaking powers as well as ownership. So now we're talking about governance being part of this. And at the bottom of the slide, we have a quote from Professor Kent McNeil, who emphasizes that Indigenous peoples have inherent governmental authority and laws had it even prior to European assertions of sovereignty. So again, it's not new. This is pre-existing, and it relates to governance. And this is important because Section 35 should be interpreted as including governance as well. Now on this slide is former Supreme Court Justice Ian Binney. After he retired, he concluded, maybe I hope it wasn't just because he retired that he concluded, but he says that the right to control the land necessarily implies self-government, and it is self-government tied to Section 35. So you have a Supreme Court Justice in taking the view that your rights in Section 35 include governance. And I think it's your...
So, we just wanted to include one thing from the Truth and Reconciliation Commission in this presentation. We talked a little bit about it in the previous presentation, but the TRC did include the UN Declaration in a lot of their work, and the commissioners concluded that the UN Declaration is the framework for reconciliation in this country. And in their calls to action, they had 94 calls to action aimed at various segments of society. Call to action 92 is aimed at the corporate sector. And they urge the corporate sector to use the declaration as a framework and also to obtain FPIC. And I think that this is important too, in that all governments in Canada at federal, provincial, municipal levels have made commitments to honor the calls to action of the Truth and Reconciliation Commission. And so we wanted to include that as well. Seeing FPIC is also there, and there's also been political commitments to the TRC. And this is also from the UN Declaration, Article 34. And again, going back to governance. So in this article, in 34, the Declaration is affirming Indigenous peoples' institutional structures, distinctive customs, spirituality, traditions, procedures, practices, juridical systems, and customs. And I think that that's important, tying into what Paul is saying, that in the context of FPIC, governments have to respect Indigenous peoples' governance systems and Indigenous peoples' law-making powers and decision-making, and that's all part of the bigger picture of the respect for FPIC. So where's Canada on FPIC? That's $1 million question. Don't I wish I had the answer? So Canada has made political commitments to FPIC, At the Permanent Forum on Indigenous Issues, Minister Carolyn Bennett, on behalf of the Government of Canada, has announced on more than one occasion that Canada supports FPIC. This comes from her speech in 2016, and we included this one because she's also commenting about the breathing life into Section 35 and recognizing it as a full box of rights. And she's recognizing free, prior, and informed consent. A year later, at the Permanent Forum, she made another speech, and in that one, she commented on the fact that the Government of Canada had been asked by Indigenous leadership, and they are responding to the ask, for them to formally withdraw comments that the previous Harper administration had made at the UN, where they had listed their concern around FPIC. And so she said, you know, we're formally retracting those statements, and they were affirming that FPIC is critical to the UN Declaration. So formally, the Government of Canada has political statements saying that they support FPIC. And I think it's a big frustration in lots of places that we don't see that playing out enough. And I think that in our other presentation, we were talking about the Private Members Bill 262, which is currently before the Senate, which is about implementing the Declaration. And I think that one of the things that we hope to see that achieve is to help be advancing, moving these political statements into realities. And so finally, I just have a couple of slides here on culture. And this is Article 8 from the UN Declaration. And, you know, we had a good presentation today, earlier after lunch, from the elder in giving us that cultural component. And one of the great things about his presentation is tying, you know, these concepts that we're talking about FPIC, but what does that mean? You know, and what does that mean if he's speaking in his language and in his worldview? You know, what is that about, and what's it about achieving? And so that kind of ties in nicely to this already prepared presentation. That cultural rights and consent are also connected. And Article 8 is about Indigenous peoples have the right not to be subjected to forced assimilation or destruction of culture. And I think that we often are aware of that in the context currently in this country in relation to Indian residential schools, but it is more than that. And this article names the right in that first part of the article, and then it goes on to name the state responsibility. And the state has a responsibility for both prevention, but also redress for any action that deprive Indigenous peoples for their integrity as distinct peoples or their cultural values. And also any effect of dispossessing them of their lands, territories, and resources. And obviously we know how deeply connected culture and land are, and that when Indigenous peoples are being faced with challenges from resource extraction on their territories, that's not just about what's going on in the land, it's also about how that's affecting culture. And if any act is actually going to threaten their integrity, then that is something that falls into the same provision and the same rights about consent. And the next slide goes on to explain that, goes on further on that same theme. And again, taking you back to another international committee where Canada has a legal obligation. So this is from the covenant that Canada ratified in 1976. And they made a general comment in 2009 that was dealing with culture, and they said that this is a core obligation. So Canada has a legal commitment, this is a core obligation. And as part of it, they say that to encourage the participation of Indigenous peoples in the design and implementation of laws and policies that affect them. In particular, state parties should obtain their free and informed prior consent when the preservation of their cultural resources or way of life and cultural expression are at risk. So tying consent and the need to achieve consent when cultural integrity could be at risk. And then finally, Paul's just going to give a few slides on himself, sustainable development.
And in discussing sustainable development, it's good to recall that Indigenous peoples have the right to development. Often when you hear of a new development project, they act like the only show in town is that development that non-Indigenous peoples want to carry out. Of course, Indigenous peoples have their own objectives and plans for development, and they can definitely include cultural development, as Jennifer mentioned, safeguarding that culture. And in Article 8.2 that Jennifer read out, it didn't just say as peoples or as indigenous peoples, it said as distinct peoples. So that again makes it very strong. It's not just as peoples, which is strong, because peoples have the right of self-determination. But as distinct peoples, you definitely have the right to protect your culture. Or otherwise, it's going to be assimilating or destroying your cultures through 1,000 cuts. A little here, next project more, and then when you look back after a number of years, you say, where did most of the culture go? And this is wrong. All cultures contribute to the heritage of humankind. This should never be happening. So I just mentioned that. Now, going to sustainable development, that can be really useful to indigenous peoples. And the two quotes are from the 2030 Agenda for Sustainable Development. I put the full reference at the bottom of the slide. And this is really important because the 2030 Agenda is the main document. There's one instrument that's the most important. It's the 2030 Agenda when we're dealing with sustainable development. And the General Assembly has reaffirmed the 2030 Agenda at least 11 times by consensus. So Canada is totally committed to this over and over. And if we look at the top slide, it says sustainable development includes a number of key elements. And so I'll mention them. End poverty and hunger. And all of these relate to indigenous peoples as well. To protect human rights. So everything we spoke in the earlier session and this session on human rights, it applies to having sustainable development. You can't say your human rights are relevant here. Promote gender equality and the empowerment of women and girls. And finally, environmental protection. And the same 2030 Agenda resolution mentions that states pledge that no one will be left behind, and states will endeavor to reach the furthest behind first. And the General Assembly has also mentioned by consensus that when they say reach the furthest behind first, it includes indigenous peoples. So they've made that very clear, because often you're disregarded or ignored or just figure they can trample upon your lands and resources with new developments. Now, the American Declaration, Article 19, Paragraph 1, I put it down here because it goes further than the UN Declaration in terms of specific mention of sustainable development. And as Jennifer mentioned earlier, when you're looking at both declarations, on any given issue, it's the one that has a higher standard that becomes the new minimum standard. So it's good to use both declarations together. And it says indigenous peoples have the right to live in harmony with nature and to a healthy, safe, and sustainable environment, essential conditions for the full enjoyment of the rights to life, to their spirituality, cosmovision. Sometimes they use worldviews. In Latin America, they use more cosmovision, and collective well-being. And collective well-being is very important. Whenever you see well-being, that's important because it's an obligation of result. We're talking about if they're ever suggesting something where it doesn't lead to indigenous well-being, then it wasn't meant. They didn't meet this standard. And Jennifer, I think you read earlier that the minimum standard is in the Declaration, Article 43, is the survival, dignity, and well-being. So if you're in negotiations or discussing with governments on a specific project, if they give an interpretation of the UN Declaration or the American Declaration, which you think does not lead to your well-being, that interpretation is not acceptable. It doesn't meet the minimum standard of well-being. And well-being is a very important term. It exists 4 times in the Charter of the United Nations, so it does have legal meaning. So here we have an excerpt from The Future We Want, which is the outcome document from a Rio +20 conference back in June 2012. And in regard to implementing sustainable development strategies, states recognized the importance of the UN Declaration at every level, from global to local, and you can see it on the slide. And The Future We Want has been endorsed by the UN General Assembly by consensus. So again, that gives it more weight. Now, the Rio Declaration on Environment and Development was in 1992. It was actually, I believe, the first international instrument that used the term sustainable development. And in Principle 3, which you see on the slide, it says that development must not only be addressed from the point of view of the states, but also, well, first I'll quote it. The right to development must be fulfilled so as to equitably meet developmental and environmental needs of both present and future generations. So you have a right, which you always do as Indigenous peoples, to look towards the future, 7 generations or whatever. And development, therefore, must not only be addressed from the point of view of states and third-party interests, it clearly has to be from the Indigenous viewpoint. And in addition to Indigenous peoples' right to development, Principle 22 underlines, which you see at the bottom of the slide, that Indigenous people and their communities have a vital role in environmental management and development because of their knowledge and traditional practices. So that would always include as well Indigenous traditional knowledge. So that's basically the presentation.
We have a few minutes left for questions.
I have a question. It might be a stupid question.
No such thing as stupid questions.
You can ask anything you want.
Is Aboriginal right a human right?
Yes,
Yeah.
we discussed that in the first.
Yeah. So, is there competing views with both rights? Do they compete against each other?
Aboriginal rights are, whatever Aboriginal rights are, whatever your rights are, they are human rights. There's no competing view. And we also mentioned earlier that if, let's say you're Ojibwe, I don't know, but if you are, you have the right to be who you are under the Declaration. You don't have to be like Inuit or Nation Haudenosaunee. You don't have to be like anyone else. You can interpret this Declaration according to your own history, culture, worldviews, etc. That's what the Declaration says. Preamble of paragraph 2.
There's an interesting book that's out there right now. I haven't read it in its entirety yet, but I just started reading it, and the book is called Aboriginal Right is Not a Human Right,
Yeah,
which is an interesting book. And it, for me, in the territory I come from, we do have fierce frontier mentality. And so as part of that fierce frontier mentality, they have perceived rights, and so we have rights as well. And so they have rights to recreate. But in terms of the First Nation, we also have rights to exercise those rights that are inherent to us. And sometimes recreation poses impacts to those rights. Because if you start, as an example, this big ski hill here, First Nations are not able to practice the rights in that ski hill because they can't shoot guns in there to get their harvest, So for me, I seem to think that there's a little bit of competing views between Aboriginal right versus human right, and I'm not too sure if that's been fleshed out enough to see where those competing views are and how do you take care of that.
Well, I do have that book you mentioned. I just don't think a lot of it is accurate. Especially, I remember it's been a while since I've read it. I don't think that they fully appreciated that the Declaration does let you be who you are. And if it lets you be who you are, how is it contradicting your rights? If the Declaration says you determine, you interpret the UN Declaration from who you are, and maybe another indigenous people does likewise. But if it's saying you can be who you are, how does it contradict you?
And I think also somewhat what you're talking about is the balancing of rights. So,
Yeah.
I mentioned that earlier, that maybe sometimes me exercising my human rights is gonna come into conflict of how Paul wants to exercise his human rights, which is how human rights are relative. Because I don't have, that's why they're not absolute, because then we would just constantly be in conflict. So then we have to balance my rights against his rights, and the way that human rights work is you have to take the facts and the law into account in every situation. So, in a situation where perhaps a settler community feels like their rights are being minimized because they're to respect indigenous people's rights, then rather than that escalating into a conflict situation immediately, then it's where the balancing of rights comes in. And indigenous people's rights being human rights, and the rights that are affirmed in the Declaration being human rights, gives them a high level of respect is demanded because they're indigenous people's human rights. And there has to be, the balancing has to take place. But I think that it's also, we've seen that play out in lots of conflicts where, and Paul gave the example earlier today about in the case where Quebec wanted to secede from Canada, and they wanted to violate the human rights of all the indigenous peoples who are currently living inside the boundaries of Quebec by saying that they were going to take them with them, whether they wanted it or not. And that doesn't work. That doesn't work in law because they would be violating their rights. And so it really is, in situations like that, it's about the balancing of rights and about the Declaration. The Declaration is affirming indigenous peoples' rights when they're individual rights that you may hold as an individual, but also the collective rights that the nation holds. So both of those are encompassed in the Declaration.
I could just add that it was actually the Harper government who didn't want to recognize that your collective rights are human rights. Because human rights gives it more weight. We know that there's all these conventions and treaty bodies that are looking carefully to see whether countries like Canada are respecting the human rights of Indigenous peoples. The Harper government didn't allow a single civil servant during the 9 years that he was Prime Minister to even discuss the issue. They just wanted to take the position that your rights are not human rights. And they took that position not to strengthen you by saying, oh, they'll be stronger because your rights aren't human rights. They did it because they know that human rights would mean more international scrutiny, instruments applying to you, and that's what the international system has done. That no one is forced to be what they are. So whatever you say as a people are your rights, no one can say, well, you shouldn't have interpreted it that way.
Thank you.
I have a question related to Ontario environmental assessment. Under the municipal class environmental assessment, the Ministry of the Environment, which represents the government of Ontario, delegated to the proponents obligation, duty to consult. That means very often duty to consult do not constitute full consulting obligation or obtaining the consent. From legal perspective, what do you think? Do you see very often they will send the information about the municipal class environmental assessment. Not necessarily will receive the response from the First Nation communities and will proceed with the project to the completion. And sometimes it will go through, sometimes maybe the community or the representative of the community will object to this approach. What's your opinion from legal perspective?
Well, according to the Supreme Court, they can't Crown can't delegate its responsibility through the duty to consult. The Crown retains that duty. It can allow corporations to try and carry out a portion of it in terms of consulting, but the duty stays, it doesn't go to the corporations, it stays with the Crown. So if the corporations don't carry it out well, the Crown still has the responsibility. If it did part of it well, that would be taken into account in terms of the Crown's duty. Now, we just add that, yeah, in a lot of cases, people are trying, or governments, or municipal governments, are trying to get away from recognizing that Indigenous peoples have any right to say yes or no, right? In other words, they don't recognize consent, and they like to keep it as just consultation, and then they do what they want. Well, all we're saying here, international law, as it's developing, consent is becoming very important. And secondly, I said earlier that the right of self-determination of all peoples, which includes Indigenous peoples, has existed in the covenants and was ratified by Canada back in 1976. So for over 40 years, Canada has had a legal obligation to respect and promote Indigenous peoples' right of self-determination. So again, none of this often is used by many provinces or municipal governments, but I think it's up to Indigenous peoples more and more as you become more familiar, so you feel, you know, that some of this is being helpful, that you keep raising and saying, no, don't keep going back to colonial standards. We didn't set any of these standards. They're human rights standards, and they're international, and Canada agreed to have obligations here under the treaties they ratified. So you apply those standards. But it's going to be a fight before consent is more recognized.
As far as I know, it's consistent fight. Because the municipal government feel in large majority, if they communicate to the First Nations about the project, and if they, the First Nation didn't respond immediately or respond with delay, the project can go without objection.
All I'd mention again is Truth and Reconciliation Commission Call to Action 43 tells municipal governments as well as territorial and federal and provincial governments to use the UN Declaration as the framework for reconciliation. So they've specifically mentioned municipal governments. And again, it's helpful if you are aware of these things to bring it up and say, no. Are you saying you're now against reconciliation? Because if you do not use the UN Declaration as the framework for reconciliation, you're going against the whole PRC. You know, again, all of this will take some time to develop, so don't be intimidated if there's like too much information all at one time. But if you go slowly, according to your own pace, you will slowly build up that knowledge and those arguments. And there are many people that can, you know, help along the way.
Did you have a question here, and I think we have to wrap up?
So I'm currently finishing my law degree at UT, where I'm specialized in the duty to consult on my law degree, writing specifically about the how the really recent 2017 National Rights Done Supreme Court decision, as it refers to Chapter 11 of the Yukon Umbrella Final Agreement with the land use planning, how that could be developed Canada-wide, and I talk a lot about FPIC and how it does not include a veto, and I wish I had your guys' presentation when I was developing that project, because there was so much pushback when I was defending this my paper and my specialization on that it's not like that the veto and FPIC, as I was saying, are not the same thing. Exactly as you were saying, there was so much pushback from faculty and people who are actually have had their whole life work with duty to consult in the Ontario government, and saying it's not true. So I guess my question is if you could maybe, if you have anywhere else to direct, because I was directing to UNDRIP, and that there's so much pushback with it, right? And that was just, I defended it in May, so it was super recent, and even though UNDRIP, as you guys were talking about, it's been like affirmed in Canada, there's still so much pushback about the veto and how it's not the same.
I think that one of the things that happened is that the previous administration, and one of the historical interesting facts about the UN Declaration, the UN Declaration was being completed at the time when we had a federal election, when the Harper government came into power, like literally in the last months of the development of the Declaration. And Canada, under the Paul Martin administration, had been playing quite a constructive role. And the Harper administration came in, and they were like, we're not interested. And so then that actually cost them politically on the world stage because they did a big flip-flop. But one of the things they did enormously successfully was a fear-mongering campaign on that, the sky is falling, right? If we recognize the UN Declaration, the whole country is gone. And the biggest boogeyman in there is FPIC. And so I think that they, industry will stop, the Constitution is doomed. I mean, they said it all. But they did it really well, and they sold the argument to media and to corporations, so that now we're in a place where we're still overcoming that, where people got this messaging, this terrorizing of the effect of a human rights declaration. And so, which is of course the opposite of what human rights declarations are meant to do. And so I think that we're still in that place where overcoming those very bad arguments that were very heavily perpetuated by that government. And I would recommend to you the paper, like we have some copies of it up here, where, Paul spent, because that was something that was coming up over and over and over again. And so Paul spent a fair amount of time doing that research on what's the difference between veto and consent. And I think that when people can actually sit down and understand what FPIC is, then the fear part can dissipate. We've actually seen that the corporate world is getting there faster than the government world is, and corporations recognize that in fact it's good for business to be supporting consent. And so I think that and we see that at the international level as well as the domestic level. But I think that even though this particular federal administration has taken a really different position on the UN Declaration, people are still, particularly at the bureaucrat level, struggling with getting over that boogeyman around FPIC. But take one of these for sure.
Yeah.
Just to go a little further, if we take the Supreme Court of Canada, which often falls short, as we saw recently, they have a rule interpretation that they apply to the human rights in the Canadian Charter, which is in Part 1 of the Constitution, and well, Section 35 in Part 2, which are the human rights of Indigenous Peoples. And the rule is that you should only interpret Canadian Charter rights. Whatever interpretation you give has to be at least as great as what exists in terms of Canada's international obligations. They've used that rule over and over. Now, as we mentioned earlier, one of Canada's international obligations is the right of self-determination, which includes consent. It's the right to choose, yes or no. They've never applied it to Part 2. So in my view, it's discriminatory. You cannot apply a rule that's so categorical to one set of human rights and not apply it in the same instrument even to other human rights. And again, that hasn't been litigated. But stuff like that can get to the root. Because what we're dealing with is shifting from colonialism. And the court is often, unfortunately, I say this with great respect, in a colonized construct. And we've got to move them into a human rights contemporary context. So don't give up on their view.
So I think,
Professors aren't always right.
yeah. I think we're out of time, but we do have some copies of the veto consent paper up here for those that want it.